Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, counsel, and welcome to the Court of Appeals, although this is probably not like the last time you were at the Court of Appeals. But we appreciate you participating in this video Zoom conference. We've determined that in light of the pandemic, this is the safest way and the best way for us to transact business, and we appreciate you participating with us. Take just a few moments before we get started and introduce our panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. The hearing this morning will be conducted as if you were in the courtroom. Obviously, each side gets 15 minutes to make its oral argument. The appellant may reserve up to 5 minutes in rebuttal time if he or she so wishes. Otherwise, we'll conduct it specifically as if we were in the courtroom. Mr. Hivner, anything we need to take up before we get started?
I know, Your Honor.
All right, you may call the first case then.
Yolanda Carter versus Maurice Butler.
We'll hear from the appellant.
Good morning, Your Honors. May it please the court, I'm Richard Reichert of Memphis, Shelby County Bar. I'm here representing the appellant, Maurice Butler, in this matter. Before I begin, let me note that my connection seems to be a bit unstable, so if you miss hearing something I state, please let me know and I'll try to restate it again.
All right, sir. We appreciate that.
At issue is the interpretation of a one-page document, if I can find it, an agreement between the parties. At the hearing, the testimony, and after the testimony and deliberating, the trial court held up the document and said that this was and asked rhetorically, was this a lease or a lease purchase agreement? The court then went on to address the fact that there were numerous terms referencing it being a lease, and then noted that there were some terms that reference a lease purchase. So that was the ambiguity in the agreement. So the determination had to be whether it was a lease or a lease purchase agreement. From the beginning, Mr. Butler, my client, the appellant, his position has been that it is a lease purchase agreement. At least it was intended to be that way. Now, Ms. Carter's position is that this is a finance agreement. The background to this is that Mr. Butler at the time was operating two businesses, a human service agency that provided service and support for people with disabilities, and Mac Investments, which provided, among other things, housing for those individuals, making it affordable. The house in particular that we're dealing with in Memphis, he bought in 2008 through a foreclosure. He made numerous repairs in it. He also had to make numerous alterations, such as widening the hallways, changing the bathroom into a large wet room, things of that nature, in order to make it accessible for individuals that were disabled. In mid-April of 2013, one of his employees, Ms. Miller, asked him if he had a place that she could lease. They met at this property. This was the only property at that time that he had available. And with her was her sister, Ms. Carter. Now, when they looked at the house, Ms. Miller said, asked how much he was wanting to charge for it. He said he had been charging $1,000 a month since he had the house, but he was looking to raise it up a little bit to $1,100 or $1,200 a month. Ms. Miller stated that she couldn't afford $1,100 or $1,200 a month, so that was it between them. But Ms. Carter expressed an interest in the house, but she said she really wanted to buy a house because she was already renting. She really wanted to buy a house. So Mr. Butler said, well, let me think about it for a few days. Let me see if I can come up with some kind of way we can make this work. A few days later, they talked by phone, and Carter indicated that, again, that she couldn't afford $1,100 or $1,200 a month. And Butler, and tried to work out something for $1,000 a month. They went to his office thereafter. He pulled up a document that was previously used for the property, the lease agreement for the property. And he altered it slightly to accommodate the fact that this was going to be a lease purchase agreement as opposed to just a lease agreement. He did make notations as to the other terms for the option on a separate piece of paper. They agreed the option price would be $65,000. The $10,000 deposit would actually be a down payment, and that would be credited to the purchase if she exercised that option. They then went about they signed the agreement. They went over everything.
Mr. Ricard, the terms you just mentioned, were they in that one-page document that both parties signed?
I'm sorry?
Terms you just mentioned, were they in that one-page document that both parties signed?
No, they did not. If you're talking about the option page, which is Exhibit 2, they did not sign it, no. And it was not referenced in the agreement, neither. The one-page document was the only thing that was actually signed, but they did discuss both. At least that was Mr. Butler's testimony.
Let me ask you a question, please, sir. Obviously, we've had this case once before, and it
Correct.
was remanded to the trial court with some instructions to make some findings. One of the issues that was sort of hanging out there was this second page, purported second page. What did the trial court specifically find about that second page?
Judge, I don't know that he actually made a specific finding. He found that the agreement was a lease purchase with an option to buy at the end of the agreement. So he obviously noted and agreed with Mr. Butler that there was an option to buy at the end of the agreement, but he did not make any further reference that I recall as to the second exhibit, the option agreement.
Okay. Was there ever any testimony regarding the value of the property?
Yes, there was testimony, and I don't have it I can't pull it up immediately, but there was testimony. I asked Mr. Butler specifically the value of the property, and I don't recall the amount he said, but I think he said maybe 80-something thousand or something like that. I'm not sure, but that question was posed to him.
Okay.
So at the end, anyway, it comes down to, is this a finance agreement, as Ms. Carter alleges, or is this a lease purchase agreement, as Mr. Butler alleged? The court found the ambiguity to be whether it's a lease or a lease purchase. It did not find an ambiguity with regard to whether it might be a finance agreement. Now, in its ruling, it said that since she made the payments, the property should be deeded over to her, which would have been fine had he also included the sales price, which was part of it, which was the $65,000. But he didn't include that. He just stated that it would be deeded, it should be deeded to the plaintiff in this matter. So in essence, Mr. Butler is required to transfer his property that he hasn't been paid for to Miss Carter. The monthly amounts that he was charging were the same rental amounts he had always been charging. If you look at the lease, if you look at the agreement, I mean, this is obviously a lease, at least minimally a lease.
Are you holding up one page or two pages?
Yeah, this is Exhibit 1, lease purchase agreement.
Oh, that's the one-page document.
It is the one-page document.
Okay, I'm sorry, I can't. I saw you hold up a document. I couldn't tell if it was one page or two pages.
Yeah, it's just one page. There was a second page, and that was the options agreement. It wasn't signed, it wasn't referenced. It was just noted, and they had gone over that when they met in his office before signing it. Now, if there was no testimony about any of this, and we were simply looking at a document, this one-page document, I don't think there'd be any dispute that this is an issue whether it's either a lease or a lease purchase. I don't think anybody, without somebody coming along and saying,
Mr. Ricard, how many leases have you seen where the risk of loss passes to the tenant?
I believe all of those. I have exhibits 9 and 10 or 9 and 11 contain other leases on that property and other properties that Mr. Butler owned. They all had the risk associated, the risk to be borne with the tenant. So that was not unusual. All those were leases.
Are you saying that's a common provision in a lease, that if the property is destroyed during the terms of the lease, the tenant would be responsible for that loss?
Well, I don't know how the law would interpret that necessarily, but I do note that in all of his leases and in other leases I have seen from other individuals, they do contain, many of those others do contain the risk of loss to be borne by the tenant. But you can reference exhibits 9 and 10, I believe it is, and see that on that property, previous leases, and on other property where it's previous leases, all those do bear the loss or force the loss to be borne by the tenant. But
Tell me, what's the difference between a lease purchase agreement and a land contract, Mr. Ricard? A land contract.
I'm sorry, you broke up.
Can you hear me? You know the difference between this lease purchase
what's the difference between a lease and
lease purchase and a land contract sale? Yes. Because this looks like a land contract.
Numerous other terms are omitted from this, as far as the closing costs, who bears what, things of that nature. Amortization schedule. A good case to look at, if you want to look at a case that shows a question whether this is a lease or lease purchase, is the estate of Darnell, which which Carter actually cites to. In the estate of Darnell, the court found that the agreement was in fact even though it had tenants and landlord listed, the fact that it had a sale agreement, it had an amortization schedule. It specifically stated that there was a deed that would be transferred at the conclusion of the matter. There was a balloon payment. None of those things exist in this case. Nothing in this case on this paper would indicate that this is a finance agreement.
You've used your time, and I think you've addressed Judge Armstrong's question as well as can be at this point. You have your rebuttal. We will hear from opposing counsel.
Good morning. Good morning. My name is Scotty Wilkes. I'm representing the appellee, Yolanda Carter, in this matter. I would submit to the court that the trial court in this case properly interpreted that one-page agreement at issue in this case. The trial court found that this was a confusing document. It was drafted by Maurice Butler, but it was confusing on its face. In Tennessee, and the court analyzed that document according to Tennessee law. It looked at the finding and it made a finding. The court looked at the facts and circumstances surrounding the transaction. What was the party's intent? Who drafted this document? And the credibility of the parties. The appellate, Maurice Butler, in my opinion, would have the court to disregard the law in the facts and circumstances surrounding this transaction of the document. They want the court to focus on the one phrase in this document, which is the lease purchase agreement. If you take that title out of there, you still have a document that is confusing on its face. And I think that's what the court looked at in this matter. This document is confusing as to what the parties were intending to do. And when the court looked at that way, you have to analyze the court according to Tennessee law. When the facts started lining up, the court properly interpreted this document. The parties, when they first met, they met by incident. It met by chance. The sister of the appellee was trying to rent a house. Appellant went with her just to be going with her. After the sister bagged out of the deal, the appellant, Ms. Carter, asks, do you have any properties for sale? She specifically pointed out facts that was known to Mr. Butler. The court made findings that he knew about it. She was losing her job. Her job was ending. She was getting ready to get a severance package. Not only that, she was going to be applying for Social Security disability. All these facts was made known to Mr. Butler, and the court found those facts. The court also looked at the fact that she made testimony in this trial. Ms. Carter made it known to her, Mr. Butler, I'm already rented and I don't need to be renting. I'm not looking to rent anymore. I want to purchase. When all of this came together, he came together with terms to accomplish what she's trying to get to, that is to be a homeowner. He drafted an agreement, one-page agreement. This is what we submitted to the court, that allow her to get to her goal of owning this house. Nothing in this case, nothing in the facts or testimony surrounding this transaction suggested there was going to be an option at the end. There's nothing in agreement referencing an option at the end. This is how I think the court looked at this matter. This is not uncommon when you have people who have bad credit. You have people who try to help them to accomplish what they're trying to get to, knowing that they're not going to be able to get financing. That's another fact that was made known to Mr. Butler. I can't get traditional financing. This was made known to him. And the court has to look, the court further looked at the fact that all of this stuff, all of this was made known to Mr. Butler when he drafted these documents. Circumstances surrounding this case that suggest that this was just a lease, where it's a lease if you fail to complete the agreement. It was a purchase if you completed the agreement, and that's what she did. Renters do not invest $18,800 into a property that they're renting. The court saw this, that this is uncommon for someone to do something like this. Renters do not put down $10,000 security deposits. This is not common of a lease. And on top of that, the court found that Mr. Butler said this was not intended to be a security deposit. It was intended to be a non-refundable down payment. Renters don't do that. The court looked at this document and saw—
What did the court find about that $10,000?
The court, it made reference that she paid the $10,000 down, and that it was and that he agreed that his testimony was that it was not intended to be a security deposit, but a non-refundable down payment. That's what he had in his revised order. Nothing in agreement suggests that Ms. Carter had to do anything other than to pay $1,000 a month and pay that $10,000 down. When she completed this agreement, she contacted Mr. Butler about transferring the title to the property. She thought she had did everything she was supposed to have been doing. This is how the court looked at it. Mr. Butler at that time started alleging that there was more terms to it. They went back and forth. He said to her, "Send me what you have." She sent him the one-page document that she had. She told him to send me, if there's anything else, send me what you have. He never did that. As I said in my brief, Mr. Butler did not produce the second page until we got into discovery.
And what did the court find about that second page?
The court didn't make no reference to the second page. It didn't make any findings as the second page. So I'll submit to the court that this is just my theory of it. I submit to the court has some questions about that second page. One of the things that the court did make note of, that the credibility of the parties. He found that Ms. Carter was more credible than Mr. Butler. Although it's not in the order, it was in the testimony. The alleged second page, like I said, was not produced until we got into discovery. After Ms. Carter called and inquired about it transferring the property. This second page, as the court has already made reference, it's not signed, it's not initialed. The one-page document does not make reference to the second page document, nor does the second page document make reference to the first page.
Let me ask you, Mr. Wilkes, at the trial, did your client testify that second page was never presented at the time this agreement was entered into?
Yes, she disputed that she's ever seen, she ever saw the second page. She did testify to that. Mr. Butler, one of the things that
let me ask you another question, Mr. Wilkes. What about the property taxes? There seems to be some dispute about who paid property taxes or who was supposed to be paying the property taxes.
That was her testimony, that they was going to discuss that at the end. There was nothing in the property in the agreement regarding the property taxes. Ms. Carter's testimony is that that's what they were supposed to have been doing when they got ready to do the closing on this property. Discuss who's to take care of the property taxes. I mean, this is an agreement where not uncommon with people who have financial difficulties, who have bad credit. If she completed the agreement, it was going to be a lease. It was going to be a purchase. But if she didn't, it was a simple lease. And
Okay.
she the risk of
Let me change gears on you a little bit. What about the improvements? The proof is some improvements were made to the real estate during her term of possession, and they seem to be fairly significant. What was the proof regarding that about everybody's knowledge and acquiescence and all that?
The court in its testimony, in its revised order, found that Mr. Butler knew about the improvements. The testimony that came out at trial is that when Miss Carter, I keep saying Miss Butler, but Miss Carter, when she got her lump sum Social Security disability, she went to Mr. Butler's office to try to pay this off. This is 18 months ahead of the schedule. At that point, if you calculate from March of 2016 up to October of 2017, that's 20 months. If Mr. Butler had told her at that point that this is a lease and you're gonna have to come back and pay $65,000 at the end, this lady could have, excuse me, I didn't mean to say it that way. Miss Carter could have walked away at that point instead of paying an additional $20,000 in rent and losing, and then putting $18,000 investment. That's $38,000 that she's losing because this was not brought to her attention.
I understand that. Let's talk about the improvements though for a minute. So did Mr. Butler know about the improvements? Tell me what the evidence was.
The court found that he knew about, in his revised order, the court found that he knew about the improvements. There were testimony by Miss Carter that Mr. Butler had came to her house after she had made the improvements and while they were going on. He saw this when he came there. And if I'm not wrong, I might be wrong about this. I believe her testimony said he was kind of shocked or surprised at the improvements. He didn't say nothing to her, but he saw the improvements. When he came there for something, I forgot what it was, he came to her house at least 2 times after she had made the improvements into this home. So the court found that he knew about it, but never said anything.
And what was the value of the improvements? Was there a dollar figure put on that?
Yes, it was rounded. It was $18,833.
Okay.
There was statements and testimony, receipts produced to show that that's what she put into it. The court, she brought pictures into the house of all the improvements that she made. It's in the court's revised order showing that she had scraped the ceiling, installed recessed lighting, hardwood floors, crown molding. I don't know what wine coating is, but updates in electrical. She did all of this to a house that she's thought she was purchasing.
Mr. Wilkes.
Yes.
Mr. Wilkes, was there any proof as to whether Mr. Butler had any advance knowledge that Ms. Carter was going to do these things, or whether she had ever informed him that it was her intent to make these improvements?
Excuse me, Your Honor. No, Your Honor, there was no notice or testimony regarding any kind of advance notice or anything like that.
Thank you.
Mm-hmm. Your Honor, at the end, I would just submit to the court that the trial court did properly analyze this document and interpret it in the according to Tennessee law. It was confusing on the face, and the court had to get to the point of seeing what was the party's intent. I submit to the court that Mr. Butler drafted an agreement to accomplish what Ms. Carter was trying to do, is that is to become a homeowner.
What was your client understanding about the purchase price, Mr. Wilkes?
I can't remember because it was 55 or 54. I can't remember, Your Honor, what she testified to. That she thought the only thing she had to do to pay that $1,000 a month.
That was 54 months, $1,000 a month.
I can't remember exactly what was her testimony. It's about what was the price on it. But she didn't think that she had to do anything more than just pay what she did. the $1,000 a month plus the 10,000 down.
All right. Anything else for Mr. Wilkes? Seeing no other questions, we'll hear from appellant in a rebuttal.
Thank you, Judge. Mr. Wilkes argues that that Mr. Butler was presented with a situation where Ms. Carter was stating that she couldn't get financing and she wanted to purchase, not rent. Mr. Butler tried to work with her in this regard. He said, why don't we just do a lease purchase to allow you the time to get your credit better? He initially proposed 2 years. She said that her credit was really bad, so they went to 4.5 years. So he tried to work with her in that regard. The $10,000 was a down payment, and that was to be credited. That was for the option, basically, and to be credited toward the purchase if she exercised that option, which it appeared she was going to do. She signed this document, so she's bound by this. She can't claim that whatever it ostensibly says shouldn't bind her to it because she had some other understanding.
Well, let me ask you the question that Judge Armstrong asked Mr. Wilkes. What was your client's understanding of this agreement as far as the cost, the payment for this real estate?
The court found in the findings of fact that the purchase price.
I'm asking what your client believed.
What my client believed initially?
Yes. What your client's position is as far as the purchase of this real estate?
That it was $65,000.
And
that was the court.
With a credit of the $10,000.
Correct. And the court found that. And I mean, I think part of the problem may be that it's just a mere coincidence that the total of her rental payments comes close to the purchase price. But it isn't the same thing. We're talking about.
You say it's a mere coincidence, but doesn't that suggest that maybe they agreed that the purchase price was $65,000? So she paid $1,000 for 54 months. You add the 10 to it, you come up with 64. It's not quite 65, but that could be a matter of poor math, like poor drafting of the agreement, couldn't it?
Well, obviously, I mean, if you're talking about just an error being made, well, certainly an error can be made. But I think that, but there's nothing to suggest there was an error made. They went with this 4.5 years extension, this time period, to allow her to get her credit improved.
But why 4.5 years, Mr. Riker? Why 4.5 years? Why 54 months? That seems like an unusual term for a lease.
Well, they didn't get into the testimony and say, the negotiation of the time period. He testified, he initially suggested 2 years because that's time he's found that people normally need to improve their credit. She said it was much worse, so they talked some more. She said 4.5, so they went with 4.5. I don't think at that time, nothing indicates that there was any reason for them to believe that there was that it matches. But where's the option? I mean, the judge, the trial court found there was an option in this matter. Where is the option and how was it exercised? And we're dismissing the fact that if the option basically was automatic, that the lease payments just somehow converted to being the option. I mean, it makes the terms tenant, landlord, all those irrelevant.
Let me ask you another question. What's your client's position on these improvements?
I'm sorry?
What is your client's position on the $18,000 improvements that the appellee made?
He testified that toward the end of the lease agreement, he went there and he did notice what he thought were repairs on the ceilings and things of that nature. This is a one-time visit, and he was surprised to see that, but he didn't start anything. Now you got to keep in mind that as far as he knows, she's about to buy this property. Further, it's not unusual for somebody who's staying in a property for a long period of time to make some improvements to the property. He didn't indicate that he knew the extent of all our improvements. He went there to do some repair work. He was required to do, he paid the taxes, he did all the maintenance. Everything indicates that he was treating this like this was a lease at that time, not a purchase or finance agreement.
All right, sir.
I see that my time's run out, so I guess.
Yes, sir. Gentlemen, we appreciate your argument. We will take this matter under advisement and endeavor to get you an opinion at the earliest possible date. We again appreciate you participating in this Zoom oral argument, and Mr. Hivner and the AOC for making it all possible administratively. So with that being said, Mr. Hivner, if you'll recess this case until the call of the next case.
This honorable court is now in recess until 10 a.m.
Thank you, Your Honor.